right, ladies and gentlemen, welcome to episode 9 of this podcast. Once again, we'll be giving you random questions to help you with your bar review. Okay, for the first question, which takes precedence in conflicts arising between employers, management prerogative, and employees' right to security of tenure, and why? Again, the question is, which takes precedence in conflicts arising between employers, management prerogative, and the employees' right to security of tenure, and why? Okay, what do you think is the answer? Okay, the answer is that the employee's right to security of tenure takes precedence over the employer's management prerogative. So, mulabaw gid ang kaning right of security of tenure. Okay, so this is important because the right of every employee to security of tenure is protected by our Constitution. Thus, an employer's management prerogative includes the right to terminate the services of the employee. But this management prerogative is limited by the Labor Code, which provides that the employer can terminate an employee only for a just cause or when authorized by law. This limitation on management prerogative is because no less than the Constitution recognizes and guarantees the employee's right to security of tenure. All right. Let's proceed now to another set of questions. Okay. What is the foundation of the Agrarian Reform Program under the 1987 Constitution? Again, the question is, what is the foundation of the Agrarian Reform Program under the 1987 Constitution? Who are the direct beneficiaries of this program? What do you think is the answer? Okay. The answer is the 1987 Constitution enunciates in Article 2 as one of the state policies that states shall promote comprehensive rural development and agrarian reform. Another provision of the Constitution, if you look at Article 12, it says that in dealing with national economy and patrimony, it is also stated that the state shall promote industrialization and full employment based on sound agricultural development and agrarian reform. Then in Article 13 of the Constitution, in dealing with social justice and human rights, there is also a provision, among others, that the state by law undertake an agrarian reform program founded in the right of farmers and regular farm workers who are landless to own directly or collectively the lands they till, or in the case of their farm workers, to receive a just share of the fruits thereof. To this end, the state shall encourage and undertake the just distribution of all agricultural lands, subject to such priorities and reasonable retention limits as the Congress may prescribe, taking into account ecological, developmental, or equity considerations, and is subject to the payment of just compensation. In determining the retention limits, the state shall respect the right of small landowners. So it's very important that we consider also those small landowners. So they will provide for the retention limits or what will remain to the small landowners. The state shall also further provide incentives for voluntary land sharing. Taken together, the above provisions could be considered as the foundation of the Agrarian Reform Program, and that led to the implementation of the comprehensive or the signing of the Comprehensive Agrarian Reform Law. The lands covered by the Comprehensive Agrarian Reform Program shall be distributed as much as possible to landless residents of the same barangay, or in the absence thereof, a landless residents of the same municipality in the following order of priority. So number 1, take note of this. Agricultural lessees and share tenants. So those are the first in priority, followed by the regular farm workers. So take note of that, okay? Next is that after having prioritized the regular farm workers, we proceed to the seasonal farm workers, followed by other farm workers and actual tillers or occupants of public land. So you need to include them. And collectives or cooperatives of the above beneficiaries. And also include others directly working on the land. All right, so we have a very comprehensive discussion about that. Let's proceed to the next question. Okay. The next question is, what is tripartism? Again, what is tripartism and what is the binding effect of an agreement entered into a tripartite conference? Again, what is tripartism and what is the binding effect of an agreement entered into a tripartite conference? Alright, what do you think is the answer? Okay, this is the answer. The tripartism in labor relations is the policy of the state enunciated in the Labor Code. So if you look at Article 275 of the Labor Code, which is implemented by consulting with representatives of workers and employers in the consideration and adoption of voluntary codes of principles designed to promote industrial peace based on social justice, or to align labor movement relations with priorities in economic and social development. The codes of principles adopted at the tripartite conferences are voluntary. So take note of that. It's voluntary. They do not have a legal binding effect. Okay? So please take note that it has no legal binding effect on the workers and the employers. Antay. But because these codes are considered and adopted by representatives of workers and employers, they are likely to be complied with voluntarily by the workers and employers. Kaya kamo na nagsabot-sabot diha. Okay, another alternative answer is that you should not bind unions and employers organizations that were not represented in the tripartite conference because they are not parties or signatories to any agreement arrived at the conference. All right, let's proceed now to the next question. Okay, what are the acts that are considered illegal recruitment, whether committed by any persons, whether a non-licensee, non-holder, licensee, or a holder of authority? Okay, again, what are the acts that are considered illegal recruitment, whether committed by any persons, whether a non-licensee, non-holder, licensee, or a holder of authority? Okay, can you guess the answer? Okay, there are specific acts here that are enumerated. First is charge or accept directly or indirectly any amount greater than specified in the schedule of allowable fees. So, what is written there in and as initiated by the provisions or the administrative issuances of the Secretary of Labor and Employment, if you go beyond that, then automatically you are doing illegal recruitment. Patay ka. Okay. Next is to furnish or publish any false notice or information or document to recruit for recruitment and employment. Patay. Okay. To give false notice, testimony, information, or document, or commit in any act of misinterpretation for the purpose of securing a license or authority under the Labor Code. So if you lie just to have a license, then automatically you have committed illegal recruitment. To give any false notice, I've mentioned that. And B, to induce or attempt to induce a worker already employed to quit his employment in order to offer another job unless the transfer is designed to liberate a worker from oppressive terms and conditions of the employment. And next is to influence or attempt to influence any person or entity not to employ any worker who has not applied for employment through his agency. To engage in the recruitment of placement of workers in jobs harmful to public health or morality. And next is to obstruct or attempt to obstruct and to obstruct or attempt to obstruct inspection by the Secretary of Labor and Employment or by his duly authorized representatives. And next, to fail to submit reports in the status of employment of placement vacancies and remittances. So if you fail to submit, as may be required by the Secretary of Labor and Employment. Okay, next, to substitute or alter or to the prejudice of the worker employment contracts approved and verified by the Department of Labor and Employment from the time of actual signing thereof by the parties up to including the period of expiration of the same without the approval of the Department of Labor and Employment. Kadaghan ba ni? For an officer or agent of recruitment placement agency to become an officer, member of the board of corporation engaged in travel agency or to be engaged directly or indirectly in the management of travel agency. Bawal. And to withhold or deny travel documents for applicant workers before departure of monetary or financial considerations other than those authorized by the Labor Code. So, yung imong kolektahon, mora gid ang nakasulat sa Labor Code, ha? Okay, failure to actually deploy without valid reasons as determined by the Department of Labor and Employment. Okay, and failure to reimburse expenses incurred by the workers in connection with his documentation and processing of purposes of deployment in cases where the deployment does not actually take place without the worker's fault. Illegal recruitment when committed by a syndicate or in large scale shall be considered an offense involving economic sabotage. All right. Let's proceed to the next question. Okay, A began to possess a parcel of land in 2003. B began to do the same in 2007. Sunod-sunuran. Okay. All right. Again, A began to possess a parcel of land in 2003. B began to do the same in 2007. And both are actually there. Whose possession will be recognized? Okay, what do you think is the answer? Okay, A's possession as a fact will be recognized since his possession is longer. The provision that we can quote is Article 538 of the Civil Code. The law does not say there cannot be two or more possessors, as a matter of fact, called actual possessors. They can indeed be, as an example above given, but the law does not recognize that there should be, from the legal viewpoint, two actual possessors, save in the case of the exception already discussed. Now, if you look at the book, only one of the two actual possessors will be recognized in law, and the one which has an older possession will be more preferred by law. Okay. Question. Irma and Brian are buying a house. If the house burns down after they sign the purchase agreement, but before the house is turned over to them, who takes the loss? No? Again, Irma and Brian are buying a house. If the house burns down after they sign the purchase agreement, but before the house is turned over to them, who takes the loss? Okay, what do you think? Okay, the answer is the seller is liable for the loss. Because the seller is still the owner. No, take note. There is no transfer of ownership yet. The principle of res perit domino applies. The thing perishes with the owner. In the law on sales, the ownership of the thing is transferred to the buyer after delivery. So if you look at the provision, that is the obligation of the seller that you deliver. And once there is a delivery, there is a transfer of ownership. Okay, next question. Is there any distinction between the labor legislation and the social legislation? Again, is there any distinction between labor legislation and social legislation? Okay. The answer is that labor legislation is sometimes distinguished from social legislation by the former referring to labor statutes. So yung labor legislation is actually referring, no? Referring to the labor statutes, like labor relations law and labor standards, and the latter to social security laws. Labor legislation focuses on the rights of the worker in the workplace. Social legislation is a broad term and may include not only laws that give social security protection, but also those that help the worker secure housing and basic necessities. The Comprehensive Agrarian Reform Law could also be considered as social legislation. Okay, let's proceed to the next question. On December 12, this is a story. Okay, magic. On December 12, 2008, A signed a contract to be part of the crew of ABC Cruises. No? Oh, bakit ganun? Again, in December 12, 2008, A signed a contract to be part of the crew of ABC Cruises Incorporated through its Philippine Manning Agency XYZ. So dumaan siya sa agency. Under the Standard Employment Contract of the Philippine Overseas Employment Administration, or the POEA, his employment was to commence upon his actual departure from the port in the point of hire, Manila, from where he would have take flight to the USA to join the cruise ship MS Carnegie. MS Carnegie. However, more than 3 months after A secured his exit clearance from the POEA for his supposed departure on January 15, 2009, XYZ had not deployed, XYZ has not deployed him, and it was for no valid reason. Is A entitled to relief? No, and explain. Okay, what do you think is the answer? The answer is yes. Even if no departure took place, the contract of employment has already been perfected, which creates certain rights and obligations, the breach of which may give rise to a cause of action against the erring party. No, so take note. No, he is entitled to his relief. Okay. A can also file a complaint of recruitment violation of XYZ's failure to deploy him within the prescribed period without a valid reason, a ground for the imposition of administrative sanctions against XYZ under Section 2, Rule 1, Part 5 of 2003 POEA Rules on Employment of Seafarers. At the same time, A can file a case of illegal recruitment under Section 6 of Republic Act number 8042, Employment of Seafarers. Okay, A may also likewise file a complaint of breach of contract and claim damages therefore before the NLRC. Despite the absence of employer-employee relationship, Section 10 of Republic Act number 8042 conferred jurisdiction on the labor arbiter not only on claims arising out of EER, but also by the virtue of law or contract involving Filipino workers for overseas deployment, including claims of actual, moral, exemplary, and other forms of damages. Okay, so please do read the case of Santiago versus CF Sharp Crew Management. Okay. Okay. So we have reached the conclusion of this podcast. Thank you so much for joining us. And we would like to thank everyone and send our prayers to our bar takers. No, we wish you all the best for your preparation. Please don't forget, again, we would like to request everyone to please rate this podcast 5 stars so that we'll be able to continue doing this content and we'll be able to help more people ace their bar examinations, and at least we'll be able to continue helping others. Thank you so much for joining us, and See you in another episode of this podcast tomorrow. Bye bye.